Before Judge McGrath, it was our motion to dismiss 3,042 cases, outstanding warrants.
The district attorney in Manhattan is seeking President Donald Trump's tax returns from his accountants for the purpose of a criminal investigation that is being undertaken in New York City. Both a lower court and then a federal appeals court in New York ruled that the accounting firm called Mazars has to comply with the subpoena and turn over the president's tax returns. The president went to court in New York to try to stop that subpoena from being enforced. So far he has lost, and his next step is the Supreme Court. If the court decides to hear the case and issues a decision in late June, it could be a significant decision regarding the president's immunity or lack of immunity from any kind of investigation while he's in office. If the Supreme Court decides to hear the case and issues its decision in late June, it would be right at the height of the presidential campaign. The election at that point would be just a few months off, and whatever the Supreme Court had to say could have an effect on the campaign. If the Supreme Court decides not to accept Trump's appeal, then the subpoena would be able to be enforced. There'd be no other place for Trump to go to try and block that. And the accounting firm, which after all is the entity that holds the records, has said it will comply with the subpoena if that's the final order of a court. In which case, at some point shortly after the Supreme Court acts, which could be in January, perhaps a little bit later, the records would have to be turned over. Although they wouldn't be made public, they'd be provided to the district attorney as part of a grand jury investigation.
Under our Constitution, it has always been held that justice does.
There are two earlier cases that may be relevant. One was the Watergate tapes case during Nixon's presidency. The other was the lawsuit filed by Paula Jones against Bill Clinton while he was president. In both cases, a unanimous Supreme Court ruled that the president would have to comply in Nixon's case by turning over the Watergate tapes, which led to his resignation, and in Clinton's case by participating in Paula Jones's sexual harassment lawsuit against him, which led to the president's impeachment.
Hear you, ladies and gentlemen, and all of our listeners tonight, that I have no greater interest than to see that the new special...
Yeah, the Paula Jones case was about a lawsuit in federal court, and the Supreme Court said then that the president had to participate in that case and couldn't use the fact that he's in office as a reason to avoid it. But the court in that case left open whether the circumstances might be different in the case of a state investigation. That's what the New York DA's case presents. There's no way to know if that would turn out differently. There's a second case involving the president's financial records, and that's in the federal appeals court in the District of Columbia. It poses a very similar question about whether a subpoena, but this one issued by the committee of the House of Representatives, can be enforced against the same accounting firm, the Mazars firm. It's possible that the Supreme Court will want to consider those cases together, but the case here in Washington is not quite ready yet for the Supreme Court. The full appeals court in Washington has been asked to hear the case, and there's been no decision on that yet.
Opinion justify that level of enforcement, and we are trying to even out racial disparity and rationalize and right-size